Hello, everyone, and thank you for joining us for the first installment of A New Political Reality, our three-part webinar series on new risks and new opportunities for business in the evolving 2025 political landscape. Today's topic is the Trump 2.0 administration. My name is Sarah Bonk, the founder of Business for America. A big thanks to our promotional partners who helped get the word out about this series, the American Bar Association Task Force for American Democracy, Business for Social Responsibility, the Business and Democracy Initiative, Citizen Connect, the Fulcrum, and State Business Executives. If your organization would like more information or to help promote the rest of the series, please reach out to our marketing director, Chip York, at chip@bfa.us. For those of us joining for the first time, a little about BFA. Business for America is a business membership organization, a national nonpartisan nonprofit, and we focus exclusively on how companies and business associations can help foster a healthy representative democracy, greater bipartisanship, and effective government. Our member companies come from across the country in all different sectors and sizes, from Fortune 500s to small startups. At the core of our mission is the understanding that the business community has a bottom line economic interest in protecting our democratic institutions, and that this is a genuinely nonpartisan issue. We also believe that talking about the problem is not enough, so we work with businesses to take meaningful action together. And we'd like to invite your business or business association to become a member, and you can learn more at bfa.us. So today in session one of A New Political Reality, we are focused on the Trump 2.0 administration. And before we get to our panelists, I want to set a little context. As we noted in our event description, our country has a long history of presidents who seek to expand their power. It's what they do, and the framers of our Constitution anticipated that. It's why we have checks and balances. So how do we know when a president has crossed the line versus politics as usual? And if someone does cross the line, what should be done about it? These questions reminded me of a little story I want to share that I think brings these concepts to life. So back in 2017, I found myself in Montana for the first time in decades. I was taking a shuttle to a conference, and we were cruising down the highway, and I saw the speed limit signs. And I told the driver that I thought there weren't speed limits in Montana. There certainly weren't when I was there as a child. The driver explained that there had been the case for many years. There had been this reasonable and prudent law, which you see on the sign here, and that worked well enough when the spirit of the law was respected. But then, wouldn't you know, along came a guy who was ticketed for going over 100 miles per hour 3 different times. And that guy decided to contest his tickets. His appeals went all the way up to the Supreme Court of Montana, who decided that the state's reasonable and prudent limit was unconstitutionally vague and subjective, and they threw out the tickets. And so that's why the Montana State Legislature adopted speed limits. So you can probably see where I'm headed with this story. It's a reminder of what happens when we don't have clear boundaries and we don't enforce our rules. Someone, somewhere, is going to drive as fast as they want. So here's a more concrete example. What you're looking at here is the number of executive orders issued in each presidential term, as well as the average number of executive orders per year from our friends at USA Facts. It may be hard to see on your screen, but these are in reverse chronological order, with President Biden at the top, followed by President Trump's last term. And we can see that the total executive orders and average executive orders per year are not out of the ordinary. In fact, that's President Carter coming up with the most executive orders per year there. Now take a look at this chart, which shows the number of executive orders signed on the first day in office. That's President Trump's inauguration there at the top with 26 first-day executive orders. That's certainly interesting. What should we take away from this information? So thankfully, we have 3 brilliant speakers lined up to tell us just that. And as we listen to their perspectives on the new administration and the history of executive power, here are a few questions for us to consider. Number 1, what executive actions are following established precedents of the modern presidency and which represent unprecedented expansions of presidential power? Number 2, how significant are unwritten norms in constraining executive power? Are there practices currently governed by tradition that we should formalize? Number 3, how have systemic failures and checks and balances promoted the growth of executive authority, such as this dysfunction that we see in Congress? Number 4, looking ahead, can we restore a balanced separation of powers, or has the modern presidency become irreversibly dominant? And number 5, what does this all mean for business, and what should we do about it? So lots for us to think about and discuss. So thank you all once again for joining us today. And with that, I will hand it off to Richard Island, BFA's National Policy Director. Richard, please take it away.
Great. Thank you, Bonk. And welcome, everyone. Thanks for joining us today. Really appreciate it. And as Bonk said, we have three really excellent speakers to elucidate those questions and provide us with some details on what's happening in Washington these days. So let me introduce our three speakers, and each of them will make an opening presentation, and then we'll get into some questions. And by the way, if you have questions during the presentation, use your Q&A button on the bottom of the screen. So we'll be hearing today, and I'm going to introduce people in the order that they're speaking. So the first person we'll hear from is James Wallner. James is a senior fellow at the Foundation for American Innovation, where he writes about separation of powers, Congress, political parties, and the federal policy-making process. James was a senior fellow previously at the R Street Institute in DC and a group vice president for research at the Heritage Foundation. James also spent over a decade on Capitol Hill in senior positions in both the House and in the Senate. Elizabeth Gauthier is the Senior Director for Liberty and National Security Programs at the Brennan Center for Justice at NYU's School of Law. She's a nationally recognized expert on presidential emergency powers and also served and worked in the Senate as a counsel to Senator Russ Feingold, chair of the Constitution Subcommittee of the Senate Judiciary Committee. And she also served for a while as a trial attorney in the federal programs branch of the Civil Division of the Department of Justice. And we also have with us, thankfully, Judge Thomas B. Griffith, who's retired from the U.S. Court of Appeals for the D.C. Circuit Court in Washington, D.C., where he served from 2005 to 2020 and was appointed by President Bush. Tom is also a member of the American Bar Association's Task Force for American Democracy and is the special counsel with the Hutton, Anders, and Kurth law firm in Washington, D.C. So thank you all so much for joining us. And James, why don't we start with you? And as we've chatted about, there seems to be a number of questions and concerns about the use of executive power already in the first 10 days or so of the Trump administration. And what we've been hearing from a number of companies is questions about the constitutionality, the legality, the adherence to process that the administration is following. And so from you, if we could get a sense as to what has happened over the past decades regarding executive power. Article 2, as you'll, I'm sure, tell us, doesn't enumerate many clearly identified powers of the executive. But over the decades, maybe since the Second World War, the presidency, each successive president has assumed more and more power. So clarify for us, if you would, give us a little history as to how the growth in executive power has come to be.
Well, thank you for having me, and thank you for having this discussion. I think it's an important one, and thank you for including me with such illustrious panelists. I make it a rule only to appear on panels with people who are much more talented and intelligent than I am, because then by association, I can elevate myself. But no, it's a really important topic, and it's one that people are concerned about. Either you are frustrated and worried and apprehensive at this moment in our history, or you are excited and exuberant at this moment in our history about what is to come. Either way, I think it's important to fully kind of step back and reflect on where we are and what actually can happen and what has happened, and to try to separate the sensationalism of this moment from the institutions themselves, so that we can get a better understanding of either the threat or the opportunity, depending on your view of this moment, for those institutions. And I think it's important to keep in mind, going back to the Constitution, that the Constitution was created to both empower the federal government to help counteract the majorities in the state governments at the time, but also at the same time to ensure that it didn't use those powers in ways that the framers and the ratifiers of the Constitution didn't want the Constitution to use them, right? So it structured the government in such a way to make it safe to empower the government with giving it more powers. The government we had before was just one Congress, one House of Congress. That was it. There was no kind of internal structure or organization that would complicate the use of power in that way. So we have the separation of powers, which is the kind of benchmark or the foundation of the Constitution, where we divide up the powers. You got a legislative branch with two Congresses, the House and Senate. They got a lot of power. You got the executive branch, and then you've got the federal judiciary. And the separation of powers is actually the key thing that helps to keep this whole government of ours in check. The Article 1 of the Constitution, the Congress, they have the most powers. And in many respects, that's because it's an enumerated set of powers that we're giving to the Congress to do certain things in the Constitution. It's also because the people, that's just what we understood. Going back to 1619, we had experience in this country doing legislative politics. We didn't have a relationship with executive power. Royal governors were something that we weren't, right? We didn't have access to that. They were royal governors. And in many respects, the patriots saw them as lackeys to the crown. And as we struggled for our independence, we struggled with executive power. So not only did we not understand it, we were very distrustful of it. But the events of the 1780s convinced us, in many respects, that executive power is needed. And so we have this national executive in the Constitution. But we impose these checks and balances to preserve the separation of powers. So the executive needs a power to protect the executive from the Congress. And so let's give the executive some of the legislative power. Let's give the executive the veto power. But let's give the Congress the power to advise and consent, and the Senate in particular, or ratify treaties. So we muddy the executive and the legislative boundaries a little bit to help preserve them so that ambition can counteract ambition, if you will. But Congress has always been front and center for most of American history. The presidency, though, is still very important. The presidency still, as James Madison writes to Thomas Jefferson, the president alone unites the conjectures of the American public, right? It's an easy way to make sense of everything. But what we see over the course of the 19th century is a growth in federal power, and along with that, a growth in the power of the presidency. Right. And then we see that especially in the early 20th century as well. And I would note the number of executive orders, they've been fairly consistent, but there's a huge spike with the administration of Franklin Delano Roosevelt, with his with the other Roosevelt, with Teddy Roosevelt. There's a huge a growth in executive orders, right? So executive power has grown over the years as the government has gotten involved in more areas. But even as it's done so via spending money and administering grant programs that Congress has approved, or it's through new regulations after the Administrative Procedures Act. So the executive is starting to regulate in more areas that are important to people and to businesses. But Congress is there the entire time, even during the height of the New Deal. If you look at the New Deal reports, when Congress would pass legislation giving Franklin Delano Roosevelt the power through all of these agencies to do things, the reporting was insane compared to what we see today. Very detailed reports from these regulated agencies, from the executive branch to Congress, to the committees of jurisdiction over what they were doing. And this growth in executive power and growth in national power was not at the expense of Congress, was not at the expense of the House and the Senate and their role in the process. I think what you begin to see change, though, in the last couple of decades is that Congress begins to delegate more and more power to the executive. And when the president either acts under the Constitution, or the president's going to act pursuant to a delegated power of the Congress. There's the only two kind of ways the president can act, right? And the Congress delegates more and more power, which in and of itself isn't new. But what is new now is that the Congress isn't exercising as rigorous oversight of the executive for various reasons, political reasons and others. They're starting to push more and more responsibility to make policy, to regulate to the presidency. And then they're kind of washing their hands of the process so that they can say, let us have clean air, and then leave it up to the presidency to determine what that means, the regulations, and then turning around when people complain and saying, well, it's not me, it's the agency that's doing this, right? And then you see simultaneously in both political parties, regardless of who's president, a tendency to not use the power of the purse, which Madison calls the most effectual power a free people can give their representatives, to not use that power to help to rein in the executive, to be less aggressive and more deferential in the confirmation process, both for executive branch officials and for federal judges. The Senate doesn't flex its muscles, to not be as assertive in the treaty making process, and to acquiesce to the presidency when the president tries to kind of approximate treaties via executive orders as opposed to the treaty making process. There's no clear, bright lines, right? These parchment barriers in our system don't work. They never have. What works is that you give the different branches of government the power to resist things that they see the other branch doing that they think are inappropriate. Right? That's the key thing. That's the thing. That's the bright line that protects us. But when one branch, in this case Congress, doesn't use its powers under the checks and balances to resist the presidency, to push back, to cut off funding, to attach funding riders, to pass new laws, right? Or to withhold confirmation of officials that they think aren't going to do what they want, right? When that happens, then things start to get out of whack. So it's not necessarily that the executive power itself is kind of out of alignment in recent decades. It's that the congressional power has almost receded. It's receded. And when that happens, the system doesn't right itself. Look, it's always ebbed and flowed throughout our history, whether it be Lincoln, whether it be Nixon or John. I mean, there's all kinds of examples of a robust executive authority and doing questionable things in very intense moments in our republic. But our system is set up to kind of rebalance itself, if you will, through those checks and balances. But that rebalancing, despite all of the rhetoric, all of the beating of the chest, all of the hair pulling, and all of the sky is falling rhetoric, despite all of that, they're not using their power in the Congress to help kind of realign the system. And I think that's the key problem that we have in this present moment.
Okay, good. James, thank you. And I think we'll dig into this idea of recourse, whether it comes from Congress or the judiciary, as we go on. But I did want to ask you just one clarifying question, and maybe you could help people understand the concept of unitary government. So this seems to be a theory that has been popularized in recent years and seems to be driving some of the decisions of the Trump administration currently. So could you just explain what that idea is for the viewers here?
Right. Well, in many respects, the unitary presidency is a fact of life, right? There's one person in the presidency. Edmund Randolph didn't like it. He said that was the fetus of monarchy, but you know what? He lost. We only have one president. We don't have three presidents. And so in that sense, the president is a unilateral actor. The executive branch is a hierarchical branch of government, unlike the Congress, where the president's up top, right? And the president kind of sets the tone and does a lot of the stuff. Now, what does that mean, though, vis-a-vis Congress? John Marshall, the eminent Chief Justice, gave a speech when he was in the House of Representatives that said the president was the sole organ of foreign policy, and the unitary presidency in particular, as I'm sure Liza can speak to, is very kind of manifests itself, especially in conservative thought, when it comes to security policy and foreign policy. But even there, John Marshall said that the president was the sole organ of foreign policy, the sole organ. But what he also said was that the sole organ meant in implementing that policy and interacting with other nations, that Congress made the policy, right? It's not that the president is the policymaker. The president is the sole organ in implementing that policy. But the unitary aspect of the presidency does give the president certain advantages vis-a-vis Congress. There's a lot of people in Congress and they disagree, and it's a messy process. And so when you need to act quickly with dispatch, when you need to repel certain things or address public fears, when you have to do those types of things, the president can take action that will reset the debate. And the last thing I'll say on this is a great example is the Deferred Access for Childhood Arrivals executive order. When President Obama issued this executive order, it changed everything. Prior to that, Republicans consistently voted to block efforts to codify that policy. But when the president changed that and issued this executive order, overnight, it's reset the debate. And now Republicans are going to be a lot less, they're more resistant, despite their rhetoric, to try to roll that back or somehow limit the president. So the ability to take unilateral action can be a very a strength of the presidency that the other branches don't have.
Okay, good. Thank you. Thank you. Let's get Liza in the conversation. And Liza, building off of what James described as Congress delegating certain authority and responsibilities to the presidency, to the office of the president, tell us how these emergency powers that the president holds have come to be. And, we've seen a number of examples. President Trump has declared an energy emergency, a border emergency. And what is the nature of a presidential decision to invoke an emergency?
Sure. And this really does pick up on some of the themes that James was talking about in terms of very generous delegations of power by Congress, and then sort of a failure to exercise what powers Congress has to serve as a check on those authorities. Let me just start by saying a little bit about what emergency powers are. Emergency powers have existed in countries around the world for hundreds of years. The idea behind them is pretty straightforward. Emergencies are by definition unexpected and unforeseen. So the powers that the law confers on the government in ordinary circumstances might not be sufficient to address them. But amending the law to provide greater powers could take too long, or you might not want those additional powers to be around permanently or indefinitely. So emergency powers give the president or the head of state in other countries a temporary boost in power until the emergency passes or until there's time, if appropriate, to change the law through the ordinary lawmaking process. Most countries, the vast majority of them, have emergency powers baked into their constitutions. The US Constitution is an outlier. It gives the president no express emergency powers. And so presidents, for the most part, with some notable exceptions, have relied on Congress to provide the authorities that the president needs in an emergency. Currently, there are many emergency powers statutes and statutory frameworks, and I'll hit some of the most important ones. The National Emergency Framework is governed by the National Emergencies Act, which gives the president the authority to declare a national emergency. That declaration then unlocks powers that are contained in about 150 different provisions of law, all of which say something like, in a national emergency, the president can do X. Now, lots of these powers, if you look at them, they're not that scary on their face, but some of them really do seem like the stuff of authoritarian regimes. For example, there's a power that allows the president to take over or shut down communications facilities in a national emergency. One power that I think is very ripe for abuse is the International Emergency Economic Powers Act, or IEPA, which gives the president very broad powers to impose financial sanctions on anyone, not just foreign actors, but Americans as well, whom the executive branch deems through a secret classified process to be contributing in some way to a foreign or partially foreign threat. This is really an incredibly potent authority, and it's one that we might see a lot of, I think, in the next few years. Congress built some checks against abuse into the NEA. The ones I'll mention are, first of all, Congress provided that Congress could terminate an emergency declaration through a legislative veto. And that is a law that goes into effect with a simple majority of both houses and without the president's signature. And then Congress also required that Congress should meet every 6 months while an emergency declaration was in effect to consider a vote on termination. These protections have completely failed. In 1983, the Supreme Court held that legislative vetoes are unconstitutional. So if Congress wants to terminate an emergency declaration today, it has to pass a law, presumably by a veto-proof supermajority of both houses, which is nearly impossible in today's political climate. And for 40 years, Congress literally ignored the requirement to meet every 6 months to take a vote on emergency declarations. So that was Congress essentially just abdicating its power in this area. So that's the National Emergencies Act and that framework. Another very important emergency power is the Insurrection Act, which gives the president the power to deploy federal armed forces to quell civil unrest or to execute the law. It is an exception, the main exception, to the Posse Comitatus Act, which generally prohibits using federal forces for civilian law enforcement. And that principle of Posse Comitatus is a key protection for democracy and for individual liberty. So you might think that any exception that Congress enacted would be very narrowly and carefully crafted. Not the case with the Insurrection Act. It is written in broad, vague, and archaic terms that provide a few clear constraints on when the president can deploy the armed forces. The initial version of the law as passed in 1792 included both congressional and judicial approval requirements as checks against potential abuse. those protections were stripped out in subsequent amendments. So it really has skewed the balance of power between the president and Congress. The final emergency authority that I want to flag isn't actually statutory. It is the claims that presidents have made, especially in recent decades, to broad inherent constitutional powers to deal with emergencies. And to give you examples of what we've seen in recent years, actually, these are both under the administration of President George W. Bush, who relied on these a claim of inherent power to justify the torture of detainees after 9/11 against the laws that Congress had passed. That administration also relied on inherent emergency powers to conduct warrantless wiretapping of communications between Americans and suspected foreign terrorists, again, in violation of the laws that Congress had passed. What's worrisome about these claims of inherent powers is they very rarely get tested in the courts for a number of reasons. Congress has the power. I mean, you might say, well, Congress already passed the law. What can Congress do if the president ignores the law? A lot, right? Congress has the power of the purse, as James was pointing out. So many things that Congress can do. Congress basically has not done those things. So, for example, after the warrantless wiretapping program, which violated laws that Congress had passed, Congress actually, instead of penalizing the executive branch, codified the illegal surveillance that had been happening. So essentially, put its blessing on the violations of Congress's own laws. Given how few constraints exist in these laws and in these powers, it's really remarkable how little abuse we have seen to date, with some notable historical examples, but nonetheless, these powers have been used sparingly and for the most part appropriately. In that way, we have been very reliant on presidential self-restraint and norms. We cannot continue to rely on those. As Richard mentioned, we have already seen Trump has already declared 3 national emergencies in his first week in office. 2 of them, I think, are a clear abuse of emergency powers. That's the declaration of emergency for the southern border and the declaration of an energy emergency. He seems to be gearing up to invoke the Insurrection Act to have soldiers conduct immigration enforcement. He has threatened to use IEPA, this economic sanctions law, to impose tariffs on Mexico, which is a clear misuse of that power. And his executive orders make the broadest claims to inherent executive powers. He hasn't yet flagged emergency powers, but it's this sort of amorphous foreign policy and other inherent constitutional powers, much broader claims than I think we've ever seen. So I think we're in for a real testing of the constitutional separation of powers and balance of power in this administration.
Okay. Liza, thank you. Let me just quickly ask you, do you anticipate that Congress will seek to change the rules, seek to restore a certain balance here, given what you've just described, or is the willingness to have the executive make these decisions something Congress is likely to stay with?
So I will say that reform of emergency powers has been a remarkably bipartisan issue over the last few years. After President Trump declared a national emergency in 2019 at the southern border, Senator Mike Lee introduced a bill to reform the National Emergencies Act, which included a very sensible way of rebalancing the power, which was to require emergency declarations to expire after 30 days unless Congress votes using expedited procedures that would prohibit filibusters and make sure any member could force a vote, so there would be no obstructionism, but Congress would have to vote to approve the emergency declaration in order for it to last longer than 30 days. 19 Republicans co-sponsored this bill, which was in response to Trump's declaration of a national emergency. The Democrats then picked up this concept and put it into their flagship democracy protection bill, the Protecting Our Democracy Act. That same bill last September was voted on in committees in both the House and Senate. The vote to pass it in the House was unanimous, and in the Senate, it was a 13-1 vote. That was before the election. I'm not Pollyanna-ish. I think given the composition of Congress, given the way Trump is governing, it's a challenge. But I think that particular issue has such bipartisan support that I am not giving up on Congress sort of reasserting itself in the area of national emergencies. Some of the other emergency powers, Insurrection Act, IEPA, some other things are more of an uphill battle. But I think, you know, it will depend on what Trump does. And honestly, he could, given what we've seen so far, he could overstep so badly and so dramatically that Congress feels the need to put some checks on his powers. Maybe not all the checks they should put, maybe not as robustly as one would hope. But again, I wouldn't completely abandon hope of a little bit of rebalancing in this administration.
Thank you. Judge Griffith, as Liza just suggested, if Congress is not likely to reassert its authority, then that leaves the judiciary as a mediator, critical player in these debates. So give us a sense, if you would, about the role of the judiciary in checking executive powers, and what have we seen over the past 2 decades? Is there a line of thought that we should be particularly mindful of, some precedents, and what is your sense about the ability of the judiciary to respond?
Yeah, great. First, let me thank you, Richard, for putting this on, and for Business for America, the good work you're doing. I'm with the American Bar Association's Task Force for American Democracy, and we appreciate all that you're doing. Our view is that this is a critical time in the nation's history. We have concerns about the strength of democracy, and these sorts of discussions are critically important for all of us to have a better sense of the history of the Constitution, the meaning of the Constitution, and the values of the Constitution, so that we can preserve them. But specifically to your question, I'll answer in some broad generalities and paint with a broad brushstroke to try and make a point. This court, the Roberts Court, cares a great deal about the separation of powers. If you go back in time and think of the historic Warren Court, it's a bit of a cartoon sketch, but you would say that was a court that was greatly concerned about individual liberties. I think the Roberts Court is as well, but they frame it a little bit differently. Justice Scalia, who obviously is no longer with us, but had and has a significant influence on the thinking of the justices, of all the justices actually, would famously say that any banana republic has a Bill of Rights. The Soviet Union has a Bill of Rights. Real liberty comes from the separation of powers, and that's the thinking that I think predominates this court and has for some while. And it's not a thinking that's partisan in nature. I think it's a reconfiguration of just how important these critical values are of the separation of powers. So I think you have a court that's deeply concerned about these issues. Now I'm not going to be real good at predicting which way they'll go on this, but there is a bit of a track record here already that shows that this court has a sense that the administrative state, the agencies, and the executive branch and the independent agencies have gotten a little too powerful, a little too removed from political accountability. The blame for that lies largely with Congress, because Congress delegates vast powers to these agencies without a whole lot of guidance. The agencies then interpret what Congress has done and exercise vast powers that this court has already shown is they're a little uncomfortable with. They're very uncomfortable with. So on one track, you have a court concerned about the separation of powers that's worried about the powers of administrative agencies. At the same time, you have a court that is composed of people who have shown an interest in presidential power and support of presidential power. A lot of these justices came out of the executive, had some significant executive branch experience at one time or another, either working in the White House or the Justice Department, and many of them have a fondness for executive power. You asked James about the theory of unitary executive theory. Most of these justices subscribe to the idea that the executive power of the mentioned in the Constitution, the executive power belongs to the executive. And that is a clear tendency they have, is to side with the presidency, with the president in his exercise of that power. I think we're going to see, as Liza mentioned, we have a particularly aggressive exercise of that executive power now in the Trump administration. I think it's going to be interesting to see as the Trump administration tests the limits of that presidential power, what this court, which is concerned about the separation of powers, will do. We've seen that already in it's called the Loper Bright case. It's a case that in effect overturned a long tradition of the courts giving great deal of deference to the administrative agencies to carry out what they thought was the will of Congress. The Supreme Court has rejected that now, and has given back to the courts more power to scrutinize what the agencies are doing, and for the courts to say, no, you've gone beyond what Congress intends you to do. There is a lot of talk, at least in the academic world and amongst some judges. We'll see if this plays out in the Supreme Court, that there's some real unease with the amount of power that Congress has delegated to the executive branch in broad terms. It's called the non-delegation doctrine. It's the idea that Congress can't delegate everything to the president. It's the Congress that makes the laws. The president executes the laws. The president isn't supposed to be making the laws. We'll see if that doctrine, that theory, has some purchase with this court. But I will say one thing that I like the way James started us off to say, let's all calm down. Let's all calm down right now. Some people are cheering, other people are concerned. Something that I think is significant to keep in mind is that in the first Trump administration, the Trump administration did not do well in the judiciary. Adam Liptak and the New York Times reports that the Trump administration lost 80% of the cases that it brought in the courts. So I think you have a judiciary that's concerned about the separation of powers. Although it's pro-executive in many ways, I know there are limits to that, and I think we may be in for an interesting ride to see what those limits are.
Yeah. Tom, just quickly distinguish for us between the roles of the district court system and the circuit court system. Sure. Before something would go to the Supreme Court. So
right. So in our federal system, we have 3 levels of courts. The first one is the trial court. That's where, in most instances, you bring your suit. When you're dissatisfied with the outcome of the district court, you appeal to one of a series of regional courts of appeals around the country. I sat on the one that heard appeals from courts in Washington, D.C. Then the step above that, obviously, is the Supreme Court. Now, the Supreme Court, except in a small handful of cases, doesn't need to take an appeal. They get to decide which cases they want to hear and which cases they don't want to hear. And that's a complicated calculus that has to do with if the Federal Court of Appeals that sits in San Francisco decides an issue differently than the one in New York, the Supreme Court's likely to take that to resolve, to come up with some uniformity. There are also cases of special importance that the court decides, no, this is an issue that we need to weigh in and decide. For example, we saw that recently with the immunity case, right? That had been decided at the district court in Washington, D.C., and then appealed to the Court of Appeals in the D.C. Circuit. The Supreme Court did not need to take that case, but they thought that the D.C. Circuit, my former court, had gotten it wrong, and so they took that case, a case of obvious national importance.
Okay, good, thank you. Liza, I know you wanted to comment on something that the judge just said, please.
Yes, and I agree with almost everything he said. I mean, I agree with everything he said. There's just a little caveat, a little asterisk I would put on it, which is while this court has constrained the executive branch in the area of socioeconomic regulation, it has had a very expansive view of executive authority in the national security space. And the problem here is that Trump is calling everything national security, and everything is framed in terms of sort of an existential threat or a military issue. He is saying that unlawful migration is an invasion in the constitutional sense of the word, triggering his powers as commander-in-chief of the armed forces. Needless to say, unlawful immigration is not an invasion, as that term has always been understood. It is not an armed attack by a political entity. However, the problem is that when presidents say that things are military matters or national security matters, courts tend to defer not just on what the president then does, but even on the question of whether it is a national security matter. That the courts tend to say this kind of thing is a political question. Now, a president can still, again, overstep so badly that the courts will step in. And what the courts have said and what the Supreme Court has said in the past is that there is a permissible range of honest judgment that a president can exceed. And there are, bad faith exceptions to these general rules that the courts will not intervene. However, I do think the way that the court acts on matters that are framed as national security matters might look a little different from some of the other trends we've seen with the court.
No, and I agree. And that's why I think it's going to be interesting to see as the Trump administration tests the limits here. I will point out that this is a court, most of whose members love the Youngstown Steel case. Now that's lawyer talk between Liza and myself, but that's an instance where a president invoking national security matters, President Truman lost in a significant way. President George W. Bush lost in a significant way on Guantanamo issues. So they can do it. Whether they will, we'll see. What's the comment Yogi Berra made? I'm not very good about predictions, especially about the future, and so I'm not good at the prediction game. But I sense that this court's interest in the separation of powers is significant enough that when there is overreach, even when invoking national security, I'm hoping, I trust that there'll be some skepticism. And Liza, I think you named the one where I'm most, I don't want to say confident, but I would predict that the invasion argument isn't going to work. Getting rid of birthright citizenship, these are extreme claims that are well outside the mainstream and are inconsistent with the method of interpretation that most members of the court adhere to, and that's trying to understand the original public understanding of the language that's in the Constitution, and by that measure, these claims are extravagant claims that have been made. So we'll see.
James, do you have a comment on that? Otherwise, I have a question I wanted to ask you.
Yeah, no, I mean, I think it's important though that when we think about the courts stepping in, that it's part and parcel of a broader system, right? And I would just caution, because separation of powers envisions three coordinate branches, coordinate meaning of equal rank, not of equal power. They all have vastly different powers for particular reasons. They all have a job to do. And if we substitute kind of acquiescence to the executive with an acquiescence to the judiciary, we're not necessarily rebalancing the system. We're just kind of throwing it out of alignment in a different way. And, I think there's a tendency on both sides of the aisle, in both conservative and progressive intellectual circles going back decades, towards a more judicial supremacy type view of the courts being the kind of the last resort or the ultimate arbiter, to borrow kind of Madison's kind of sarcastic characterization of this view to Jefferson. Right. But our system, we don't have someone above the separation of powers. The courts aren't like the gods on Olympus, like, holding lightning bolts, looking down at us mortals on the plains of Troy, trying to figure out who to smite next. They're part of the system, and there's a give and take there. And the courts, though, also, if they overstep or they do things, and I think the Roberts Court, and the Judge Griffith can correct me if I'm wrong here, is very attentive, as most courts and most judges are and justices, to this dynamic. That if you are not in alignment with where the public ultimately is, we have to remember that the court is, in Hamilton's words, the weakest branch. They have neither the sword nor the purse, and they have been disregarded openly and flagrantly, admittedly distant in American history, but they have. As Andrew Jackson says, Marshall's made his decision, let him try to figure out how to enforce it. That's a gross paraphrase here. And so I think that ultimately the courts need both the goodwill of the people, and as the Congress deflects more issues to the courts and to the executive, it's going to pull the courts down into that fray of policymaking, which is not a good place for them to be, because it limits their ability to do their role, I think. And then the courts are going to lose their ability to push back. right? And so I think that it's important that we have to approach the separation of powers as a coherent whole. There is no silver bullet and there is no answer. It's not 2 + 2 = 4 here. It is an adverbial thing. It is an architecture where people can act and react to one another. And it's that course of ambition, counteracting ambition that plays out over time that ultimately keeps our institutions in check and keeps American self-government going. There is no one right answer. And those parchment barriers aren't going to be the solution.
Here's I agree with that, James. Here's a problem with that. I don't think many American people understand what the separation of powers is about. I think most of the public is interested in outcomes, and separation of powers is all about process. For example, I'm not a huge fan of every part of the immunity decision, but the way that was reported by pundits and others, this was done to help Donald Trump, right? And it wasn't. I mean, you can disagree with the decision, but I think what's going on there, and I know that all members of the court agree with what I'm about to say, is that they're wrestling with law. That these are tough legal issues about how is the president accountable, in what circumstances can, and when, and who imposes that accountability? Does Congress through the impeachment power, or does the criminal justice system? I'm telling you, these are not easy issues. These are the stuff of law school exams, and I think I'm taking a charitable view here, but I think it's an accurate view that what the court was wrestling with there were some very difficult separation of powers issues, and yet that's not how it's generally perceived by the public. So I think it demonstrates that how difficult it is for the court to rely on a separation of powers rationale for a decision that can be easily characterized as pure politics. So I think James is right. They have to be very cautious about how that's perceived.
Let me ask you to then comment on two recent activities. One is the firing of 18 inspector generals, right, which was seemingly contrary to federal law. I see that Senators Durbin and Grassley have sent a letter to the White House challenging the legality of that action. And then the other seems to be a contravening of the Impoundment Control Act. So in both cases, the executive branch seems to be absorbing some of the powers and responsibility, or ignoring the separation of powers doctrine that Congress has. They establish these laws. The president is accountable for abiding by the law. Will these end up in the courts? Will resolution?
I think they're there already. I think people have raced to the courthouse and have filed them. So let me take them separately. And this reinforces a point that Liza was making, a very good point on the Impoundment Control Act. This is a big issue that has been with us since the beginning. Does the president have to spend the money that Congress appropriates? Is that something that Congress has complete control over, or the president has control over? And we go back to the presidency of Thomas Jefferson to see the first time that's disputed. And I think I know the argument of the Trump administration is, yeah, Congress has tried to limit the president's ability to spend, but we think that's unconstitutional, right? And so I think maybe we're headed to court to see what that means. You're not asking for us to express our biases here, but I will. In my past, before I was a judge, I was actually the chief lawyer for the United States Senate for a number of years. It was a nonpartisan position. So I have a bias here. And the Constitution, the spending clause of the Constitution gives that power to Congress. So I'm of the view that the Impoundment Control Act that's a proper exercise of the president's of Congress's power to tell the president when you must spend. You have, Congress can give the president a delegated authority saying you can decide whether you want to spend this or not, right? But on other times they can say, no, you have to spend this. I think that's maybe simplifying, but that's the basic issue. And the Trump administration has already signaled that they think that decision of what to spend is up to the president alone. We'll see what happens with that one.
Right. Good. Yeah. Liza, why don't you offer your perspective?
Yeah.
Then I did have two other questions I had here before we end.
Okay. So quickly, I think it kind of, to some degree, minimizes what's happening to think of it just in terms of spending, right? If it were just the case that certain amounts were allocated by Congress for a particular project and the president completed the project with less funding, there wouldn't be a conversation about, but they didn't spend the money that Congress allocated.
Right.
What's happening is that the president is trying to use the not spending of funds to not complete tasks or follow through on policies that Congress has passed. So he's using it as a way to get around the policies that Congress has put in place. And in that, it's not just that he is failing to spend funds that Congress has appropriated. It is that he is not faithfully executing the law, which is an obligation that he has under the Constitution. So I just think that's an important sort of veneer to all of that.
Yeah.
Right. Let me ask a quick question to each of you. And James, why don't you go first? The question is, this is from a member of the audience, what role do citizens, small businesses, and not-for-profits have in ensuring the process of a balance of powers and separation of powers? So what should the business community, individual citizens, and, the NGO community be thinking about here as we have this debate over appropriate separation of powers?
Well, I would say every role. I mean, ultimately, it's the people in our nation that are sovereign, right? They're the ones who are in charge, right? And they created a government through a constitution. They established a government and gave that government certain power. The Constitution is a law for that government. It's not, and because of that, that government or any one part of it cannot have exclusive authority on deciding what that Constitution means. And we have an institutional structure that is set up to ensure that it makes it very difficult for it to do so. Yes, the president can act in certain ways unilaterally, right? The president can say, I'm not going to spend this money. And yeah, there's a court structure there, a legal process that you can pursue. There is, but it's also Congress. And Congress can say, well, we passed this law. And in many cases, like the IG stuff, in many cases, it's a little bit, it's maybe not ambiguous, but Congress will say you can act, but you have to do it in a certain time frame or do this. Or they'll say, with TikTok, you can delay a sell, but it can only be under certain circumstances. And then the president can then infer from that maybe these circumstances have been met and then go ahead and act, forcing Congress to then be in a position of reacting. The problem is that Congress can't necessarily stop the president from doing something, but Congress can make the president's life, excuse my language, a living hell if it wants to. And the only reason it will ultimately want to is if the people who elect the members of Congress, their different constituencies, who elect the people of the House, who elect the Senate, if the businesses who are regulated or impacted in certain ways can come and make their feelings known and say, hey, this is the actual outcome of this. This is how it affects the bottom line. This is how it affects the jobs in this district or this state. This is how how these things work in practice. The Congress, which is the only part of the federal government that is responsive to the people in a direct way, will ultimately take action. It always has throughout American history, right? And I think the reason why Congress today isn't is because the people, just like the Congress, are looking to the courts, as Judge Griffith said, are looking to the presidency to achieve outcomes. And it's a lot easier to make sense of that in our minds. It's one person or just a couple of people, and they're going to decide this issue. And it's a lot more reassuring.
Right.
But Congress is ultimately that force. The president's a lame duck. The president is done. The president's not going to be able to run for election again. Every president, after they win that second election, they're done. And even if they aren't a lame duck, the ability to bring popular pressure or targeted pressure from key stakeholders to bear on an executive is very limited, extraordinarily limited. Congress, though, is an open book. And Congress is the place where it has to begin and where it has to end. And I would encourage everybody not to think in terms of particular outcomes. The outcomes are important. That's why we get out of bed in the morning. But you have to be kind of divorce outcomes from the process and the institutions. Because the only way that you can succeed on the outcome front and to know when it's serious, when it's not, and when you need to kind of roll up your sleeves and get involved. And businesses have always been front and center in our nation history in playing a leading role in helping to kind of structure our system and to provide guidance to our policymakers, right? But to know when to do that and to know when it's serious and when it's not and how to be effective, you have to take an institutional view of the situation. If you don't, you're either going to be tilting at windmills or you're actually going to be engaging in counterproductive ways. And I think in many respects, a lot of people will encourage certain activities in certain moments because they may have a president they like or a court that they like. But then in other moments, that kind of institutional rationale will just be picked up and taken by people who want to do things that you don't like. And then that will then be counterproductive. And I think that's the dynamic that we're in right now. So I think it's seeing these places as venues for activities and looking to the appropriate venues to where you can educate and to help people see what's truly happening so that they can then make informed decisions.
Right. Thank you. Tom?
If I can just reinforce that, the Constitution is about a process by which you make laws and carry them out. The process is everything in the Constitution. It's not just the end. It's just not getting the policy I want. It's the way we go about doing it through the separation of powers. So the practical advice I would give to folks is elect representatives who care about the separation of powers, who care about the power of Congress. When I was the lawyer for the Senate, Robert Byrd would, routinely carry his, whip out his pocket copy of the Constitution, and he would oppose a policy of the president of his own party because he thought it violated the powers of the presidency and the powers of Congress. He would do that all the time. Liza has mentioned, I don't keep up with this as much as you do. I don't know how many institutionalists there are anymore. You mentioned Senator Lee. He's a bit of an institutionalist, but I don't get the sense that there are a whole lot of Robert Byrds there anymore. And I think to support and defend the Constitution, we need to care more about the process that members of Congress stick up for congressional powers, even when they have a president to their liking, because the process is everything in the Constitution. It's not just the results that we get. It's how we go about doing it was critical to the framers.
Thank you, Tom. Liza, let me give you the last word.
I agree with what's been said, but what I will say is that in order for Congress to act the way we want Congress to act, and for voters to act the way we want, they should act in terms of these separations of powers, et cetera. Really, I don't think we need messengers out there who Congress will listen to, who people will listen to. I would love to think that the Brennan Center is that messenger, but I honestly think that it's going to be more effective coming from businesses in this country who can speak out and say, this is not how we do things in America, and it doesn't work for us. It is not working well. Those kinds of public statements, I think, would be very powerful for members of Congress, for voters. It shouldn't be powerful for the courts because they should be just ruling on the law, but you get what I'm saying. So I think that should be a takeaway.
Good. Thank you. So Tom and James and Liza, thank you so much. This has been really educational, and I have a sense we could go on for another hour. But thanks for all the information. I did want to mention just three quick things. Number one is our next session in this series is about Congress. And so I think that will be a juicy conversation about how does Congress reassert some of its authority, as we've heard from our panelists. And then in March, we're having a conversation about the administrative state. So what is happening with the federal workforce? What is the role of DOJ? And how does the business community in particular interact with regulatory agencies that may find themselves more politicized and maybe short-staffed? I do want to just remind everyone that, as Liza just said, the role the business community can play is critical, and that's what Business for America is focused on, is educating and then engaging businesses to support a healthy constitutional democracy. So if you are a business owner or work in a company and are interested in this effort, we're very eager to talk to you. And Judge Griffith, James, and Liza, thank you all so much for your time, and we'll be in touch. And thank everyone for joining us today.